Any of the KAs, really?
Yeah, yeah, I've found that I like most of the KAs. You just hard to find them.
Yeah, just tough.
Oh shit, I'm getting tired.
One ain't enough.
Yeah, it's true.
I'm asleep like a baby. Ooh ah. Guys, I can't believe how long this is taking. I mean, listen, Judge obviously putting a lot of thought into this. So no matter what the outcome is, it was obviously really heavily thought about. So, you know.
I am selling my car when it's for 1.9 million in assets for a contract that didn't.
Which is good, man. At least it was considered, you know.
Well, that's why do everything. It defaults back to common.
Okay, I've got a question. Your Yorkshire puddings. Would you rather have the ready-made frozen ones or homemade?
Oh, and Bessie's.
Here we go.
We're getting an L. It's L time.
Shut up, Adam.
This will be a, well, unsurprisingly to anyone who knows me even decently well, this will not be brief, so strap in.
Yeah.
Hell yeah, baby.
All right, so the question here before us today revolves around a contractual agreement between one Harry Brown and the Six Star Tuner Shop for the sale and purchase of a Nissan R32, specifically a clause for a right of first refusal. Now, when we talk about a contractual agreement, we think about the sort of key fundamental aspects of this jurisdiction in that we allow citizens and individuals the freedoms and rights to exercise as they see fit. One of those held most dear in this jurisdiction is the right to contract. Outside of something being so unconscionable as to offend the mind, we allow people to bind themselves to all sorts of ridiculous things. We allow people to sign away the right to sue someone when they ride a rickety ass roller coaster built 50 years ago. All these ideas are inherent to our societal fabric, and they will be reflected in this ruling. Now, the clause in the contractual language in this right of first refusal, as brought up by the defense counsel, are very accurate. It does not specify the methodology for the delivery of the notice. It does not entail who the recipient of the notice must be. It simply states the Six Star Tuner Shop. Now, in the absence of a detailed controlling provision which tells us who must be notified when, in what way, and as such, we are left to revert to a common law interpretation of everything involved with the contract, the circumstances, the people, the nature of the interactions. So then we come to sort of, the validity of the whole thing. There were some arguments here about signatures and when Miss Mushkin signed the digital addendum, and does that control? The answer is no. The signature of the digital addendum does not control. The reason being is that when both parties are presented with this document, Mr. Brown testified under oath that he was aware of the document. His attorneys clearly have reviewed it with him. He did state that he was provided it. He stated that it was his signature on the document. Everything that none of that is contested. It's all stipulated to. So the idea of did it come into effect at the time she signed it? The answer is no. It came into effect at the time, as Mr. Hayes pointed out through his questioning, of the fulfillment of the contract. For everyone's education, fulfillment of a contract has a few basic elements at common law. First, there is an offer. I offer to sell something or do something for someone. There is then an acceptance of that offer. You agree to fulfill whatever is offered to you. Then there is consideration given for the acceptance, meaning If I offer to mow someone's lawn and they agree to pay me $50 for mowing their lawn, I then have specific performance of the duty. So I mow the lawn and I get the consideration, which is the $50. So offer, acceptance, specific performance, consideration. Attorney Hayes went through that very clearly with Mr. Brown, Miss Mushkin, regarding was there an offer to sell the R32 for a certain price? Yes. Was it bought at that price? Yes. Was the car transferred to Mr. Brown? Yes. The idea of whether the contract was in effect or not is very clearly answered. The contract was in effect, the parties were bound to. So, again, now we return to the question of was the notice provision fulfilled? Well, in that case, we go towards specificity, detail. As we've said, those things were not explained in the contract. Therefore, we must go to common law. Typically, the way that we interpret these provisions or general terms is we look at the context of the original contract. So, was this in keeping with the nature of the contract? Meaning, if two buddies at a bar sign on a napkin deal to buy a pickup truck, and the other person then at the bar the next night, makes an amendment to that agreement by writing on a napkin in a similar methodology, that could be acceptable to the courts. Now, if two parties sign a negotiated, merger and acquisition agreement, and then a junior associate from that firm gets drunk the next night at a bar and writes on a napkin that there's an amendment to that agreement, well, that's a bit more questionable. But even if we apply sort of a more lenient view of things and we say, okay, I'm going to view things in the light most favorable to Mr. Brown here. So we'll go through the various disagreements here that we heard between the attorneys. The idea of could the text message have been so vague as to not specify which car it was talking about? I don't buy the argument that if the text message, is valid, that it's vague. I don't buy that because I think that the ASBO, for example, it was confirmed that it was purchased after the text message was sent. I think in terms of the flatbed and journeys, regardless of Miss Mushkin's activities of resale and secondhand sale for trade-ins, I don't think anyone is under any illusion that that text message is referencing anything but the R32. I think I can extend a logical leap to that point. So I'm making the leap that the text message was in accordance with the keeping of the contract in terms of it's written for the purposes of this jurisdiction. I'm not going to get into whether a text is valid versus a signed document, but for this jurisdiction, we'll go with it. Okay. So a text message is good enough. Yes. Is the text specific enough as to the content of the vehicle being discussed? Probably. We'll go with that. Is the text specific enough as to the familiarity between the person it's being delivered to? Is Mr. Marshall a valid recipient of that notice? I can make the leap that Mr. Marshall may be a valid recipient of that notice. Do I think that if it was me and I was trying to act in good faith and fulfill this notice provision, would I have reached out to someone else? Would I have tried multiple methods? Any of those things? Possibly, but I'm not going to put that onus on Mr. Brown. I'm going to view it in the light most favorable to both parties and most reasonable and say that let's say this text message wasn't. So now the question is the content of the text message enough?
This guy is
and here's
incredible.
Where we run into, I think, the crux of this case. Mr. Brown sent a text message, and I will read it out explicitly, and I'm going to put it up on the courtroom screen there. Bear with me one second.
This is where the loss comes. I can't see it. Oh my God.
So if y'all direct your vision there to the courtroom screen, you'll see that it clearly states, "Step bro, I'm stuck. Hey, I am likely selling my car. Is the tuner shop interested?" Now, as I've discussed, even if I accept that Mr. Marshall is a valid recipient for the notice provision, if I accept that a text message is sufficient as opposed to a formal document, if I accept that this one outreach is enough, if I accept that I can make the leap that it's only likely referring to the R32, we are left with one remaining issue, which is this text message states, "I am likely selling my car." This is a distinct problem for this court, and here's why. in this provision, if Mr. Brown or any other customer of the tuner shop under this contract were, as he claims, to be acting in good faith, and they stated they were likely selling their car, well, what happens if the tuner shop says, yes, I'd like to buy the car? Is Mr. Brown then bound to sell his car to the tuner shop? Well, that's very odd, isn't it? Because he only said he's likely selling his car, not I am selling my car. Is the tuner shop going to exercise their right of first refusal? So, in essence, what this likely terminology does, this wishy-washy sort of vague communication, not in terms of what car it's talking about or who it's being delivered to, but in terms of what he's actually stating he's doing, it presents a scenario this court cannot abide by, because if this court were to allow this to constitute notice of provision, we would be in a situation where one could tell the tuner shop, hey, Mary Mushkin, it's me, Alan Crane. I'm likely going to be selling my car. And if she said, yes, we'd like to exercise our right of first refusal, I could say, oh, never mind, decided I'm not. And now I've successfully been able to bait a situation where I can determine at my own volition, not of the tuner shop's decision, when I'm going to sell my car and to who.
True.
Which completely invalidates the purpose of the contract.
So the contract's at fault.
The reality here is
the
that
contract's
I'm not
at
asserting
fault.
This was Mr. Brown's intention. I'm not asserting he acted in bad faith. I'm simply stating that, as I said in response to the comments made by defense counsel at one point, it is entirely possible to try to act in good faith and try to fulfill the provisions of something and to fail. And as I stated at the beginning of my decision, we are a country and a jurisdiction that allows people to fail. We allow them to bind themselves to
this guy's a
contracts
fucking
that
genius.
have harsh provisions.
I'm following.
And the reason we do that is because everyone is also free to retain counsel and get advice on how to interact with those provisions. I would have hoped that Mr. Brown would have retained counsel in making the decision of how to communicate this notice. I don't know whether he did. I don't know whether he retained counsel until after the fact or not. Mr. Brown, if you did retain counsel prior to sending that text and the legal advice you got was that that text was sufficient, well, I would consider consulting another attorney about your option.
We did.
Now, in terms of the outcome of this case, the reality is the very nature of contracting allows us to enter and bind ourselves to agreements. We are then held to the standard of those agreements under the eyes of the court. This court, as stated, is unwilling to entertain the idea that a wishy-washy text message that says, I'm thinking of likely selling my car, I'm likely selling my car, it is sufficient to satisfy that notice provision. It presents an entirely unapprovable can of worms that belies the entire purpose of the contract. As such, the judgment is going to be specific performance in favor of the plaintiff. Mr. Johns, if you are still present, the vehicle was sold to you in an agreement that likely you felt was a valid contract, and maybe Mr. Brown did, but unfortunately, Mr. Brown legally did not have the right to sell you that vehicle at that time. As a result, your agreement is unenforceable by this court. You are hereby ordered to turn over ownership of said vehicle to the Six Star Tuner Shop. Mr. Johns, you do have the remedy of pursuing a claim against Mr. Brown, and that is your right, for compensation for his breach of your agreement, because he was not able to enter into it legally, and because you offered him consideration for an asset that he was unable to deliver to you, aka the specific performance, then you have a claim yourself to be brought forth before this or another court. Finally, the question of the terms of the agreement with regards to the punitive measure. This court, as referenced in other rulings before mine, such as the one by Justice Coyote in the case regarding Lenny Large's vehicle, while I may have my opinions about Mr. Brown's situation, and I may feel personally bad for him and having to pay a penalty and lose money in this situation, I hold very dear the right of individuals to contract. And if Mr. Brown was at all concerned with the provisions of the contract and the harsh penalties, well, he should have been more explicit. and he should have been more detailed in trying to fulfill the notice provision. As such, I find also in favor of the plaintiff, Mr. Brown.
Yeah.
You are hereby ordered to pay the Six Star Tuner Shop $661,250.
It's some fucking bullshit.
Tuna shopless.
Oh,
shit!
All right, we gotta fucking take that to it.
That is fucking bullshit.
This is fucking bullshit.
Snake shop.
Please, Zeus.
Yep. Thank you, Judge.
Get off my thigh, please.
Nick in the racing scene
Thank
they
you.
love so dearly. Disgusting.
This is this dumb shit.
Oh my god, well, time to blow up the tuna shop.
Over and over again.
I don't have any right now. I have to work on it.
Thanks, dude.
Yep. I got you
Harry!
13 packs.
Harry, no!
What is that jacket you're wearing?
We'll get there.
Oh, this one.
Oh, got my eyes.
What's that?
My... Oh god.
What the fuck? What's up, Bad Jack? What's up, Scruffy?
I gotta wait to grab it.
That's a cut line.
I gotta go.
Hey,
Hey, what's up, sir?
you're gonna need that.
Oh, thank you.
What do you mean likely? Tony?
Excuse me, officer. I'm likely gonna rob a bank tonight. I'm not saying that I'm gonna do it.
Aaron,
but
do you have
I'm
JJ's
likely
number?
going to rob a bank tonight.
Yeah.
What was your
A warrant for your arrest.
Hey, officer, I'm likely to kill
Can
you.
you text me his number?
Rob a bank tonight.
Put in a warrant for you.
You can't do this. It's likely.
JJ, is that you?
Hey, it's right there.
It's me.
Hey, JJ, do you want a brand new Lexus RCF? Sure. You can have it. Free.
What do you want to do? Is there anyone around us?
I need a secure lift. I need a secure transport right now.
Someone stole the
win?
fucking clown car.
Yo, Jaeger.
Bear, you have a car?
Ain't doing alive who can do it better. Don't mind the haters when they talk shit. Though their insults rain in the shredder. Just fuck it up, man, you killing this game. Body and mind so nice, the wood does it. Tripping on my words, butterflies in my stomach. Baby, don't forget me. And I promise not to forget you. Even when things aren't the best, I'll be there. Even when shit hits the fan, I'll be there. Baby, don't forget me. And I promise not to forget
Well, I'll see you guys in a month.
you. Even when things aren't the best, I'll be there. Even when shit hits the fan, I'll be there.
Actually, I might do some more shit tonight. But if nothing happens tonight, I'm dipping, boys. I need a ride to a bank. I don't think Lang gives a fuck. I think he just cares. I think he's more concerned about JJ than me. Right